I'm calling to order the Independent Ethics Review Task Force on Wednesday, October 23rd, 2024 at 6 p.m. Our first item on the agenda is public comment. Do we have anyone signed up for public comment?
No.
Thank you. Our next item is the review, the consideration of an action on the minutes of the October 2nd, 2024 meeting. Were there any changes or modifications to those minutes needed?
No.
We have a motion to approve the minutes.
So moved.
All in favor of approving the minutes?
Aye.
Aye. Minutes approved.
I can't tell you.
Okay, the next item is our workshop. Regarding the code of ethical conduct. Y'all made great progress last week and had some excellent additions. So I think we should start off and review some of those additions to finalize and confirm or modify as needed. The first addition, if I'm not mistaken, is on page 12 of 36 of the packet, but it is page 3 of the track changes document. I don't know which one is more helpful for y'all. But it is the, it was revised at the meeting prior to this last meeting, but it does not have a confirmation. So I just wanted to circulate it. It was revised to state that the official means a current or former member, so that this code still applies to those that are not currently in office. Does anybody have any changes to the modifications? Okay, so we'll confirm those. The next red line change is on page 20 of 36. It is a new section in its entirety. So those that were not able to join last week probably want to take a look at it. It's regarding the ex parte communications. After a complaint has been filed and during the pendency of a complaint before the Independent Ethics Review Board, it shall be a violation of this code, and it's basically stating to share. Correct, for the complainant, the respondent, or any person acting on their behalf to engage or attempt to engage directly or indirectly about the subject matter. Yes, or merits of a complaint in ex parte communication with a member of the Independent Ethics Review Board. So they should not approach the board and have conversations. Similarly, the board should not engage with each other and have conversations outside of an official meeting capacity. Does anybody have any concerns about the way the language reads as it's proposed? And for those that were not here at the last meeting, just to catch you up to speed, this is a similar section that has been found in comparable codes that were provided last week. I myself was not here last week, but I watched the recordings so that I was familiar with, some of the discussion points. So I think we can confirm that new section. The next change I have flagged is on 22 of 36. And this is also something that was added at the 10-2 meeting. The Independent Ethics Review Board may dismiss a complaint if it determines that the complainant refuses to cooperate in the investigation or refuses to provide requested information to the Independent Ethics Review Board. So that sounds like it's trying to curtail a situation where somebody files a complaint, possibly out of anger or what have you, and then they never respond to a request for additional information. That makes a lot of sense to me. I don't have any concerns. Does anyone have any changes or concerns? Okay, we can confirm that. I think procedurally that could help in the future. It may not arise, but it's nice that it'll be in there as an aid. So I'm uncertain. There's where it says commented recommended deletion. Has that been reviewed by this group?
I don't believe it.
Okay, so former section H, current section J states, excuse me, the Independent Ethics Review Board may conduct hearings and other proceedings on a complaint in closed executive session if permitted by state law. And it has been recommended that we delete it because all hearings are open to open to the public under state law.
And
So-
I thought the language just saying that, we also could conduct some of the business in executive session. If it's not addressed elsewhere, that it's worth keeping. Because the public might have questions about that. If we were to go into executive session.
Well, I think the hearing itself has to be conducted in the public setting, but you can have executive session, but the actual hearing portion needs to be, where you're receiving information from witnesses and stuff like that. That needs to be, open to the public.
Is that in our procedures? So I hear what you're saying is, we should at least document that executive session is available
When it is available.
when it is available.
Yeah. Because when we did hold the hearing, we did go into an executive.
Correct.
So it might be dicey if we don't otherwise have some
Okay.
language around it.
So, and this, I will need your expertise in this arena, but if I'm not mistaken, there's some sort of, I won't say ordinance or requirement already in existence about public meetings and council meetings and that you're allowed to go into executive session. I just don't know what it is.
Yeah, so that's covered by the Open Meetings Act, and under the Open Meetings Act, you're allowed to go into executive session to, for example, receive advice from an attorney. Things of that nature.
And that's how we were able to go into executive session. I had to state like clearly that we are seeking counsel from our attorney and we will dismiss into executive session. And so we used that in the last hearing that we had, or the one where we actually went into executive session.
Okay, so did we have that language in here before that hearing took place? I guess I'm reluctant to make any reference to our ability to go into executive session. Even if it's in law somewhere, but if it's not referenced in our code, that could be a question of people.
I think their concern was that it says we may conduct hearings and proceedings in executive session. I think what I hear you say is that if the hearing itself has to be, and for example, when we went into executive session, we had a discussion, but then we had to actually have an additional discussion in the open public meeting. So our hearing and our decision.
Be reworded.
Yeah, maybe get rid of hearings, like the Independent Ethics Review Board may conduct proceedings. Like,
Deliberate.
like,
Yeah, I would recommend against the word deliberate because that, again, all decisions should be made within, but we can definitely amend the wording. So if you want to do the Independent Ethics Review Board,
conduct proceedings or conduct meetings.
or go into executive.
I would say go
session.
into executive session
Okay,
as available, and you could even reference as available under the Texas Open Meetings Act.
That's a good
And like
idea.
point to that. Right.
I like that.
Then that'll allow, I think, and I am not an expert, but what I'm hearing from you and what this is saying is how it's written might actually be contradictory. Is the concern that it's saying that we can do the hearings or proceedings and we're not technically allowed to.
Right.
We'll make this.
That allows us to accomplish both.
Okay, so we'll have that adjustment for next meeting. And then for confirmation, the section J, we added this: if the complaint is dismissed by the Independent Ethics Review Board because the evidence failed to establish a violation of the code, the Independent Ethics Review Board shall not entertain any similar complaint based on substantially the same evidence. So that was so we can prevent people from continuously filing with no additional information and causing, basically city time and resources. Okay, any other changes to that, or is everyone comfortable with the way that reads? Okay. So that one is confirmed. And there's slight modification on section 2-10, where instead of will hold, it's changed to conduct. Is everyone in favor? Okay, so it's just following this on the next page on 23. Bullet F. This was added at the last meeting, the Independent Ethics Review Board.
Yeah, we already added that.
We've added that, that's in that duplicative two places.
Yeah.
It sounds very familiar.
It's on the
And F, G of page 20.
page 22.
Page 22, E.
So I think at the last meeting, there was some discussion about wanting to have it in both places, but if you you know, want to change your mind about that, we can.
Do you remember what the reasoning would be? In two places that the discussion was.
If it happens at the public hearing, I don't know.
Yeah.
It's identical, isn't it?
It's like, if it happens during the investigation, and then if it happens during
Okay.
open hearing.
That's how I remember it.
So I would think it would go under procedures only because it actually talks about the dismissal. So it leads into the procedures as within 10 business days, it can be dismissed as this, dismissed as that, or investigated. Well, I might, hold on. I might argue with myself. Yeah, that's still all under that section. And that section talks it like administratively, like after it's been filed, the board may seek and enter into a settlement agreement. So it's kind of all of the. The whole
It would
process.
cover everything. It would cover,
Mhm.
it would cover even the public hearing.
Yes.
Okay, yeah, so then we can get rid of it.
During one of our discussions, we talked about coming up with another. Like we only had three, like dismissed as frivolous, and we talked about coming up with a fourth. We done that? And why we-
What I think you're referring to is we augmented the definition of frivolous.
Okay.
So I think this is, I could be wrong, let me find it, because I think this is what you might be referencing. Maybe. Definition. There we go. Didn't we have a definition of like what would constitute frivolous somewhere? Because I feel like we defined like if it was like unwarranted or baseless or. I feel like there's a section that covers that.
We, in,
I recall the
right, in
conversation.
one of the hearings, we wished we had
Yes,
another option.
So-
Memory sometimes.
I think what we did is we brought in what frivolous meant and
Okay.
it's somewhere in here. But I want to find it because I want to make sure it addresses what. 'Cause I think we said too, like that frivolous was if it was filed. I didn't say this, but basically in bad faith, right? Like it was,
Did it have something to do with if he gets to us, but it wasn't done properly?
It's at, it's on 21 of 36.
Okay.
Section 2-133.
three options,
You look
right?
under B, there's an A
Mhm.
and then B is where,
Oh, where we define frivolous.
yeah, if a complaint should be.
Right, but I'm. One of the forms that we had gotten wasn't filled out properly. Which can have us dismiss it, but it wasn't a frivolous, it was just incorrect. Am I allowed to talk about any of those?
No details.
Okay. We got, and so that, I think that's what made us want to have the ability to dismiss something not as frivolous, but for some other reason. For an example, if somebody's, you have to be, outside a 2 mile radius of this, and they said that they were within the 2 miles. They weren't, and so it's not a frivolous allegation. It's the evidence they presented us was incorrect. Or there was something, I mean, in the case that I'm thinking of, the documentation that was provided to us wasn't filled out correctly.
So you
So
would
we
say,
wanted to be able to dismiss something.
so.
It wasn't a frivolous allegation, it was incorrect.
Could you,
Well,
could you just strike?
Do you want to use the word
strike the word
unsupported?
as frivolous?
Sorry, said it.
I said, do you want to use the word unsupported instead of frivolous?
Doug, did you say?
I said, could you simply remove the words as frivolous? For deciding if a complaint should be
You're right,
dismissed,
dismissing it.
the Independent Ethics Review Board will consider.
Yeah.
Right.
Because we discussed it, that it's not frivolous, it's just not done properly. The complaint didn't follow the guidelines for being able to get to us. So it does make sense to just give us an option to dismiss it, or have dismiss as frivolous, or dismiss as another word.
As dismissed.
Yeah. I mean, it was, you can dismiss it on a technicality, because that's what we did.
I think Doug's point's good there, that if you just drop the words as frivolous and just say when deciding if a complaint should be dismissed, the board will consider, and then all those things. And then you don't have to go into all the different possible reasons that something could be dismissed.
I mean, I think, is that the definition of frivolous, like without merit, or with, it's missing something?
Exactly,
So
it's way up left field. It's a crazy complaint.
I know, and I know,
but if you get a ticket and the cop puts the wrong date on there, or spells your name wrong, you may still have been speeding, but you're gonna be able to get that ticket dismissed because
Not completed.
the information on there was wrong.
So that's not frivolous, it's just not completed correctly.
Okay, so,
Frivolous, I think, protects us against just some outrageous.
correct, which is why we discussed adding a fourth possibility, a second dismissal. Like, we could dismiss it as frivolous, or we can dismiss it as, what would the word be? Like, if the cop writes your birthday wrong in a
It
ticket,
doesn't have to be a word,
okay.
That's why
so,
you have A and B.
you know. I could see it doing it two ways, I mean, more than that probably, but like, in my mind, there's two ways to address it. One, dropping the as frivolous, leaving it as dismissed, and having dismissed, remove frivolous, the word frivolous on B, and add, that the information provided does not support the complaint as like number 5. So these are the reasons we would dismiss, 1, 2, 3, 4, or like what we were provided doesn't even support the complaint. Either it's inaccurate, it's incomplete, it doesn't substantiate, or leave it as dismissed as frivolous, and as Andrew's proposing, add a number. Well, I would add a number 4, but like move it down, right?
Right.
Leave investigated as last, but you could say just there, dismiss because the information provided does not support the complaint. So it could be inaccurate, it could be unsubstantiated, like, and it's not, I'm nervous about being too vague because you don't want us to be able to dismiss it for any reason, because that's the point of an investigation.
And I think the complainant would want a reason, like, why did you dismiss my allegation or charge? They might deserve more than, "Look, we're just dismissing it, none of your business."
They deserve a reason.
Right, so if we just say dismissed. That's not really giving a reason, that's giving them a result. So if we say dismissed as frivolous or dismissed as whatever,
They're still gonna want to know an explanation.
yeah,
I'm so frivolous about my
yeah.
complaint.
Well, and that's where you would have to be able to point back to one of these.
Yeah.
Or if we do it the other way, 5.
Or
And I mean, I'm open to language too, if there was just a.
dismissed as frivolous or,
Seems like we've had that conversation with Meredith about this, I remember. I was under the impression frivolous covers all of that, you know, it's like, it's broad enough that, yeah, if. And I just kind of looked it up and it says, yeah, even if it's unsupported information, that it's considered frivolous. It's kind of like a legal term, I thought, but I'm not, I do remember talking about that. But
I remember that too, Anne. I agree.
yeah, and I remember saying, but, because I didn't like the word frivolous, I've never liked the word, but then she kind of explained, I thought.
There's negative connotations to the word, right, for like just like a
Yes.
regular.
It's like a legal term that's used,
we could say dismissed as frivolous, inaccurate or incomplete.
but it's like, that's what frivolous is.
Right.
So it's kind of over explaining, I guess.
It's like, well, you explain everything, like, yeah, you know, because they do say it's baseless claims or unfounded claims, nuisance claims, unsupported claim, you know, I'm just going down, all of that is considered covered by frivolous, unsubstantiated.
We could put, I mean, I don't know, we could put in parentheses, i.e. some of those things, so people can understand how we're defining frivolous, that it is all encompassing.
Or if that's their decision that's rendered. So we're dismissing it as frivolous. If you disagree, look up the legal definition of frivolous.
The explanation
Right.
could be more than, well, we just deemed it frivolous.
Right,
Yeah.
yeah,
Yeah,
like
Yeah,
frivolous, because the
give them a better
information,
explanation.
yeah, because the information was incomplete.
Would you like to add?
I
a
do think
definition?
though, like for continuity, like for different board members who might not quite have benefited from this conversation, that having the IE in there to kind of describe what we really mean is helpful. You know, just kind of leaving
I would agree with that.
a little bit of a paper trail.
What's your suggestions on IE?
So just what she described in the
I
definition.
mean, yeah, it says a claim is considered frivolous if it lacks any arguable basis in law or fact, and then it says it could be a baseless claim, an unfounded claim, a nuisance claim, harassment, unsupported claim, unsubstantiated lawsuit. Yeah,
It's a long IE.
Like incomplete or inaccurate.
We don't have that specifically, but we do have the B that it says when deciding if a complaint should be dismissed as frivolous, we will take into account the nature and publicity, the relationship and like why they filed, if it was groundless, if they reasonably should have known that it was groundless. And the evidence filing, we're taking into account their motive. So there are some things in here that we're also clarifying.
I mean, we could add, that's where maybe we could add the 5 if the claim is,
Yeah,
if the.
I like y'all's idea about adding number 5, the inaccurate or whatever y'all say.
Inaccurate or incomplete. Yeah, simple.
Any evidence that the person filing or any evidence, I'm trying to use what's like some parallelism. Basically, I'll let y'all legalese it, but the information provided by the person filing the complaint does not support the complaint itself. And that it could be inaccurate, it could be incomplete. It could just not actually,
Like if they'd done everything but didn't get it notarized.
We're putting in on paper points of argument. I mean, if we can just keep it as it is, dismiss as frivolous with an explanation why that particular complaint was frivolous, instead of being too.
and just providing it. Did we, I don't recall. Did we provide it when we dismissed as frivolous previously
It's-
in writing? I don't remember what it said.
But it was probably discussed in our meeting. and-
Yes.
It was,
Oh, it would be in the recording why we dismissed it as frivolous.
but we also had discussion about changing or enhancing the options.
Why would we need to go any further than that? I mean,
You're still gonna have to take the procedural step either way. I mean, like some of this we revised so that someone can make a more informed complaint, or we're trying to prevent frivolous complaints, or, you know, we're trying to save steps or clarify steps, but to your point, either way, the step is going to occur. I think it's a fair argument. I'm kind of in the middle. I don't see the harm in adding since there's already 4 on there, adding a 5th, but I mean, to your point, it's not. Could it potentially deter someone from filing something that they, or have somebody be more mindful about what they're submitting? Okay, it is complete or it is accurate, or my complaint does is substantiated by the information I provided. I don't know, maybe that's helpful, maybe it's not.
Also, like, your comment on 10 years from now, when none of us are on this, it's giving them an explanation as to why we use the word frivolous. They get of understanding why there's these 3 options and these 3 options only.
And I've seen it
They-
in other codes, so it's probably,
Consistent.
you have to look at like that, the model coding.
If they only interpret frivolous as shouldn't have happened versus somebody made a mistake in the evidence. I think it makes future members, it makes it easier for them to render decisions if they understand why frivolous is in there.
I couldn't hear you.
And what we really mean by it.
So where do we land?
I'm in favor of the fifth. They capture inaccurate, incomplete. Unsupported. Whatever we want to put in there.
Chris?
I like what was just said there, that we add a 5th point and says unsubstantiated or incomplete.
Thank you.
Mhm.
Wrap it up for next time.
I think what makes.
Good, actually, do you have, okay, what you need?
Yeah,
Okay.
yeah.
What were you saying?
Oh, I didn't say anything else.
Oh, I think it was.
Oh, it was you. It was coming from that direction, sorry.
So,
how many words are we gonna add? How many? I mean, is it gonna be a page full of? What are we gonna be adding here? I mean, your definition that you came up with is pretty lengthy.
yeah, and that's just one.
Where do you stop? But to make.
So
it- to
I
make it
like the inaccurate, incomplete, just because it's not captured in the others. So maybe unsupported could fall by the wayside if we're talking about adding this fifth point in some ways. The other items touch on that. But my suggestion is that we pick terms where it's truly unique, a unique contribution to how we're defining frivolous.
Mhm.
And I think getting to your point, Andrew, you really wanted it at inaccurate. Right, so inaccurate, incomplete, those were.
This isn't so much a what if, because we actually had the discussion during a hearing. So we're not, well, suppose if in the future, it's something we actually faced that we discussed, needed some kind of resolution.
Who knows, it might be a common mistake, people don't follow directions. That's what it boils down to, people don't read instructions, you know. And I know they have to sign it that when they bring it, but you know, because things could still be missing.
Your point's heard, but I think we'll draft it for
Absolutely.
now.
Yep.
Yeah. Perfect, okay, our next one is, we're back to 22. So we've removed the duplicative F that's under public hearing. That's how we went back on 23. We have a revision from the September meeting. At the bottom, it's G. We added local newspaper of general circulation. Any concerns? We did add a reconsideration section. Pardon me, section 2-103 from the October 2nd meeting. It says, if the independent, Andrew, you want to read that for us?
If the review board determines a violation of this code has occurred and imposes sanctions, the person who receives the sanctions may petition to the independent ethics review board to reconsider the matter only if there's newly discovered evidence which was not presented to the independent ethics review board during the original proceeding. The person who was sanctioned may request the reconsideration by providing written notice to the city clerk within 14 business days of the date of the independent ethics review board's written notice regarding sanctions. If the sanctioned party does not provide written notice to the city clerk on or before the expiration of the 14th business day following the date of the written notice of the sanctions, the decision of the independent ethics review board shall be final and no longer eligible for reconsideration. Did a lawyer write that?
Duh.
You got 2 weeks and you're done. When you came up with that.
It was borrowed. It was borrowed for some of the comparable.
That's a nice word.
May I ask a question? Is a letter of admonition a sanction?
Yeah.
Okay. As long as it falls in the, like, cause that's the mildest. Or the least imposing thing that the board could impose on somebody that was found. So I just wanna make sure it's covered
Yeah,
under sanction.
it's under 2-102, the new 2-102, it'll be subsection B.
Okay, perfect. So anytime that we have found against somebody, there's the opportunity to provide additional information and have it reconsidered within the timeline parameters. And it's a request, it doesn't necessarily. How do we respond to that?
Well, they have to have new evidence, so, because I remember we talked about this last time. And so it says you would reconsider the matter only if there's newly discovered evidence.
But when you say reconsidered, is that like starts the hearing over, or is it just another deliberation based on just the evidence? Or does that matter? It may not matter, I don't know.
There's gonna be another hearing.
Okay.
We'll all have to get together and
So are you
deliberate. on
saying
the
that we might need more language then, or some kind of reference that if we do reconsider, this is the procedure? How a reconsideration will be handled.
Yeah, and I mean, I don't know that that's necessary. I'm just like, if this occurs, what do we do? And if the answer is we follow what we've been doing, I mean, maybe we don't need that language. If we do something different, then that's when I would think we would need some additional language. Since this is a new section and a new like hypothetical.
We talked about it. I could be making it up, and I thought Meredith said like, yeah, we would go back and.
We have new evidence.
Bring it into the case,
We
yeah.
would decide whether we need to hear other evidence or request and.
But it's, yeah, it's new evidence, so it's like kind of opens up the case again.
Okay.
You just take it in everything else. See if it changes your mind, you know, your decision, I should say.
But it starts all over again. There's no shortcut of the process. It starts with
Yes, new evidence, yeah,
that procedure.
but we can clarify that again if we want to.
So. Yeah. I think language that redirects us to the procedure could be useful. That it's not like a cliffhanger, like what does happen?
It starts the whole process over again.
Well, it doesn't start it over, because you have the work that you did, the investigation, and now you bring in that new evidence, you know, so you just.
It picks back up at the point of where the decision was made.
Starting
basically.
at zero.
Yeah, you're
That could
saying,
be a major deterrent for like, for someone filing, like, really, now I gotta do this and this and this all over again, but if you can pick up.
I would think so, like, let's say, yeah, they're being accused of, I don't know, taking something and now suddenly, and then there was not enough information, so. Or there was a little bit and you got a little sanction, well, then a video shows up, you know. That's very clear that the person did what they, you know. Then you bring that video in and say, would that change our decision?
So when we go to the point of trying to figure out with this new evidence, should we dismiss it as frivolous? Should we dismiss it for these other reasons or investigate? Okay, so it does take a spin back to the very beginning. But we will have the background, sure,
But yeah, you don't start over,
procedure-wise,
yeah.
start.
You don't start over, you just have another piece of evidence that you didn't have before.
So what you're saying, the case is closed. Then we go back to we still have the evidence, but we go back to the beginning. Is that what you're saying?
So for the reconsideration, that's my understanding, is you just go back to the original case and look at the new evidence, and maybe you decide, no, this evidence wouldn't change our decision, you know, would change our.
Would you like, okay, so this helps my procedural thought process. If it goes back to that, because then you can just dismiss the evidence. You know, like as for, I'm not saying you should, but I'm saying like you could say we're dismissing it as frivolous, or or you choose to investigate, and then that like we before, here's who we want to talk to, here's what we want to see, or whatever it is. So that makes more sense, that you have the ability to dismiss it.
It's frivolous, because this is if there's been a sanction, so it only happens if there's, so you would say, okay, yeah. This information now, we're gonna make it frivolous.
You define frivolous.
We're not circular referencing this one.
Krista,
Okay, so that only kicks in.
Yes, Rachel.
what if we just add in the word solely? If you look at the top of that page where it says only if there is new discovered evidence which was solely not presented, basically that clarifies that it's strictly or solely or strictly not presented in the previous proceeding. Would that cover it?
I'm not sure I'm following.
I'm not sure I understand the question.
Okay, I'm reading the same thing that it was just read before, reconsideration, line number 3. We are on that same one, aren't we?
Yes.
Yes,
Yes,
it says,
Top of 2436.
I'm just not sure I'm following your thought process with respect to the.
okay,
word
I'm
soul.
just wondering if we add a word in there, because the discussion was, are we starting from scratch all over again? So kind of to prevent people from saying, if somebody's sanctioned and they're not really getting a redo, it's an appeal based only and solely if there's material that was not presented. I feel like there's some word in there on that third line.
we have only though, the first word.
Mm-hmm.
Yeah.
I mean, that's the same as solely, but
I agree. I guess what we're trying to resolve, I think what we're trying to resolve is whether or not what we have is sufficient in providing instructions on what to do next.
So if it's dismissed as frivolous, this section doesn't kick in at all.
Only
Is it-
if there's a sanction.
It may not be necessary, let me preface, but what if we just reference that somewhere in here at the very end for reconsideration, following procedure set forth in section 2-100. And then that goes right here where it's dismissed or investigated.
I'm with you on that.
So
I
then
think
it-
that works.
Yeah, okay. And that way that literally points you to like the actual next step.
Mhm.
Which, by the way, if you go on 24 of 36, section 2 dash, is it 106?
104.
There's that public records and open meetings, when we were talking about,
Oh, in accordance with the Open Meetings Act.
whatever, we were talking about.
The executive session.
Yeah.
Okay, so if we're adding that language to it, do we have any other additions or modifications to the way this new language stands? It won't be confirmed, we're gonna update it, but I just, if we need tweaks, this is a good time to go ahead and voice that. Okay, I'm gonna take silence as no modifications. Okay, so we'll move on to the next one, which is the name clearing proceedings. It's been modified and refined shorter, which is great. Any official against whom public allegations of ethics violations have been made and dismissed or determined to be unfounded by the Independent Ethics Review Board has the right to request a declaratory name clearing statement from the Independent Ethics Review Board posted on the city's website. Oh, there it is. Sorry. I had a question on this, but I answered it. Stating that no violation of the code was determined and the allegations are dismissed or unfounded. Do we need to say or unfounded if it's dismissed?
Frivolous.
That's why,
Yeah, it's dismissed, like.
Yeah. Unfounded is frivolous, yeah.
I take out
And-
unfounded.
And should we say word,
Dismissed.
should it be word dismissed, not our, it's just the verb tense is. This is, you're doing a name clearing after the fact.
so is that a forever thing?
And should this?
Yeah. You're right. I mean, I agree with
It should be
it'd
word.
be past tense, because you've already dismissed them. Now, now that you dismissed it, I'm like, hey, that's great, thank you, but can you please publish this, that you're clearing me of these allegations?
Should that be protocol when something's dismissed? So that if we dismiss something, it automatically triggers this versus somebody having to ask for name clearing?
No, because some
No.
people might say, you know what, I want this in the past, you know, don't be putting, you know, I wanna turn the page.
And I feel like there could be situations where
Just let it go.
by code, we are following the procedure, but there could be intuition. Because I think that has come up that if the code was written differently, maybe the outcome could be different. So I don't think we should set ourselves up to automatically clear a person on that basis.
In writing. Anyways, I don't see any other, so those will be the two, that'll be the revision for next time.
So did we resolve the question about whether or not we need, if dismissed or determined to be unfounded, if that's redundant?
We were recommending that it's removed, so it's just dismissed,
Just
period.
okay. In both places, on the front end and the back end of that paragraph.
Yes.
Just, I mean, is the city website enough to clear a person's name? I mean, if you're potentially destroying somebody's career with an ethics violation, you're posting on the city website, and this is just open. I mean, I don't know where I'm going with this, but how many people look at the city website to see that somebody's cleared?
So it's funny you say that, because I had written when I was first going through this, published question mark. And then I saw when I read it out loud that it was at least published on the city's website. My personal opinion is that it should be, however the complaint is published initially, it should have the same procedure. So if when we publish the complaint, it's only on our website, then I would be fine if we publish the dismissal on the website or the name clearing. If we publish it on the website and put it in the paper, then I feel like we should publish it on the website and put it in the paper. I feel like there should be consistency on how or where we do that. I don't remember off the top of hand where we publish the complaints.
I don't know if the complaints are published, but it does say here, that when you impose the sanctions and post notice on the city's webpage, and that's section that's on 23 of 36. And then it does show that when you do a letter of censure with a serious or repeated, that one you do have to publish in the local paper of general circulation.
I mean, the local paper can pick up somebody that's violated an ethics. And all of a sudden they don't publish that he's been cleared.
Cleared. It's no longer news.
We have the responsibility to post something in the paper or to do something more than just to put it on a website. Just food for thought.
No, what do y'all think?
I like what you said, Krista. Go ahead, Ruki.
I'm just clarifying, if they're requesting that they are named.
Name clearing.
What is our obligation?
I was just gonna say, what you said is appropriate and takes care of what Steve was saying. But to me, it should be the same. I mean, if a paper picks up a story, that's different than the city or a board putting it in the paper. That makes sense?
Complete sense, yeah.
And
But the damage is being done through that publication. How do you clear the guy? How do you clear the person's name and so on?
And knowing past precedents, it does and did, right? So I mean, you know, that could be expected to happen again in a future situation. So I think that's the discussion point, right? So if what happened in the past happens again and somebody gets cleared and goes through and formally requests the name clearing procedures, do we have a responsibility? But it also, there's a cost associated with that presumably.
Yeah, there's only one guarantee to get in the newspaper, and that's to pay for it.
Yeah, there is a cost. I mean, it's according to our code, we only we post the violation only on the webpage.
Cause it's a public meeting, so it has to be posted.
Now, if, again, under D, a letter, if it's a letter of censure, then it will be published by the local paper. So I guess in that case, maybe we would, I don't know.
It's not a huge fee to post something like that. And I think it's a nice thing to do, if they are cleared, it's $35 or $50, whatever it is. It's not a whole lot of money
I think it's more than that.
for a little ad, is
I
it?
was gonna say,
About
it's-
60.
How much?
I was gonna say even more, like, if,
It depends on how long we're running,
yeah.
but
Right.
the minimum is about $60.
Would it be appropriate to write out a letter that they could use on social media or whatever?
Well, they'll have our written decision.
Would that be enough?
60 or $100 too much for the city to save someone's career.
I say no.
Right, I mean,
So
I would pay it for somebody if they legitimately didn't do anything wrong, and then
So if they didn't do anything wrong, you're talking about censures, right?
They've been sanctioned and then they've been found. Or
Well,
even,
No,
we're
if-
talking about
if-
name clearings for anything.
if they were,
or yeah, for any.
if it was
If somebody
dismissed,
filed a complaint and it went to us and we didn't even investigate, we dismissed it on the front end, they could still even ask for a name clearing.
Because yeah, they got bad.
Or it went to investigation, we found on their behalf, but they would like a name clearing procedure.
I think we should think about it, cause I'm just thinking, there's so many scenarios that it could get out of control, like someone doesn't ask for it, why didn't you do that for me, I
Mhm.
had to ask for that,
And is it our responsibility?
I know.
It's not our responsibility.
And someone would say, why the newspaper, you should put it on Twitter, that reaches more people, like,
More and more you say stuff, the more and more it's a can of worms.
I know, that's what I'm saying, is
That's why I like what Krista said in terms of, you do on the back end what you did on the front end.
we should set the webpage, which is a city webpage.
Our obligation would be done duplicating that effort.
That would be fine with that. That would be very.
we're gonna provide them whatever they wanna put on Facebook, TikTok, Insta.
And that's what it says there.
The website.
That's website.
Well, that's why I keyed on that because that was my first question, just when I skimmed the section, how are we publishing this? Because if you're gonna do it, you have to put it somewhere.
Hey, it was good, it was a good discussion.
Yeah, no, it is.
See, just to be fair to the person who's being accused and cleared.
That is the last,
Put in the next bond.
that's the last red line I have.
So just to confirm, so what is the language that you want?
For the name clearing,
Yeah.
we're removing the unfounded component, which is, and leaving it as dismissed on both places. And we're leaving it as is with respect to the city's website.
Okay, leaving that.
I think there's a word missing before the word be. Should it be to be posted on the city website? The third line.
Well, if you keep going, has the right to request a statement be posted. It's like it's a very long sentence.
Okay.
It is all one sentence.
You have the right to request it be posted.
Oh.
But your it is just. Extensive.
Never mind.
So
Two in there.
and that last would be word dismissed.
Thank you.
Yes. And that's the only changes I have in that particular section. So our last consideration of an addition that has not been discussed as of yet is with respect to retaliation. Several codes across various cities have retaliation statements. It's basically just to state overtly, transparently, we will not retaliate and you are not allowed to retaliate against somebody who reports. And usually we put in good faith in private sector, but they don't appear to use that kind of language. It's very common in codes to just say, we want you to report. If you see something, say something, we're not going to retaliate against you. And some of these take it a step further that says any city official that's been filed against cannot retaliate against the person filing. I think some of these get extensive. Again, from a private sector standpoint, almost every code of ethics I've ever seen has a retaliation statement. It's usually, they're usually not this long. I've highlighted the city of Missouri City, where it just says retaliation prohibited. A city official shall not intimidate or discourage any person from filing an ethics complaint or from testifying. Although this one doesn't say after as well, but I don't personally think it needs, if we decide we should add it, that's the first discussion. Like, do we think it's necessary? It may not be necessary. If it is, then, you know, where do we land with respect to verbiage? So do we find it helpful or do we find it unnecessary?
See it as a. So
You're gonna file a complaint under retaliation.
I'm on this board. File a complaint.
They kick me off my board.
Right, and then like, okay, we're done, like you're done on that board. Is that considered retaliation if you don't reappoint somebody?
Yes, I'd be in favor of some retaliation verbiage.
As well. And I agree with you, short. I picked out Covington, Washington was pretty short. And to the point, but you're right, you know, Niles, Illinois, that just goes on and on. I mean, but Covington was kind of right to the point. So paragraph has to move on down the road.
Only thing I hesitate about that language, it seems more appropriate in a workplace environment when they're making references to job salaries and such.
With respect, because I actually like the one right below it too. If you get rid of employee, obviously, an official may not retaliate against an individual for reporting or participating in an investigation of a potential violation of the code of ethics or.
Short and sweet.
That's good, but what happens if they do?
Yeah. And that's the other thing I was
You
thinking.
have to, you're opening up another possible investigation section. But is it okay to do that? You know,
But if not ethics, where would retaliation fall under? In which,
for officials.
yeah,
When Alyssa went to the criminal. I mean, it could go, like, if I say, you're just not getting reappointed to this board, not a big deal. If I went so far as to do something criminal,
That's a criminal. act.
right, then. Cops will deal with it.
Somebody's career is
Or
on the line
civil.
because they reported something that's
Mhm.
not a
Yeah.
criminal act, that's
Well, that goes back into like whistleblower if it's like law, right?
Mhm.
Yeah, there's state laws.
Yeah, so I mean, like, if it's on the legal arena, there's already laws for whistleblower protection. But if it's board related and administrative related, I think the best example is like, if I file a complaint and they're like, oh, Krista, your term is now up, you know, and that could very well be construed as retaliatory. And then if this section existed, then I could in fact file a complaint against whomever kicked me off and then have it reviewed and let the board decide if it is in fact retaliation. Now, it does open up a whole nother section that somebody could file a complaint regarding, but don't, you know, is that within the purview or the arena of a code of ethical conduct? I say yes.
I would
My
say- I would
personal
say
opinion
yes.
is yes, but I mean, I just want to be transparent. I mean, it does cause another another layer of possibilities. What is
Could be. It's a public meeting. They walk to the left.
That's the public comments part.
but I think we should put something in there.
How do we feel about Annapolis if we remove employee and change it to our code name?
Fine, I'm okay with nothing.
And I am open, Anjali, if you or Meredith have slight tweaks to that, because we're gonna review the language itself, but something very concise. That just says, don't do it.
So where should it go?
That is. Excellent.
I don't know, I was looking.
Well, I was in my head thinking about that because when I said it's in another. Usually it's its own section, so I would say. After penalty for filing false complaint and before the administrative public records, I think you could do like a section 2-105 again, you know, or 106 or whatever it is, and just call it. Prohibition of retaliation, I don't know. Your choice on verbiage.
So I was looking at it, I was trying to first compare city of Missouri City to Annapolis, because they're both very simple. Missouri City just references a city official versus Annapolis doing official and employee.
Yeah, you'd have to strike the employee, because this is
Right?
not covered.
And then just below Missouri City with Stamford, Connecticut, they say no person. So is there some value in extending this in cases where it's beyond?
I think our code though is limited. I think our code is limited to the governance of city officials. Like employees have their own requirements and citizens, I mean, that they're not subject to. The vendors wouldn't be subject to.
Right.
We want to put something at the end of it, so if you violate this clause. Maybe open to further charges. We're gonna create a rule. Let them know that if you violate that rule, there's. Punishment. Or is it just?
You know what, this might be the wrong place. Sorry, I hear what you're saying, I'm
I
holding.
mean, or it doesn't matter, you violate anything in this document.
That's what
these
I
are
was-
the potential.
That was what I was going to respond. Just because all of the sections and I would in fact. What if it's after? Um. Section 2 dash, what comes right after?
Putting it under definitions, I thought. Yeah, we probably did that.
I think it gets muddy as far as like a violation, like you can't violate a definition necessarily.
Okay.
It would need to be somewhere in the meat, but I want it to be around, I mean, I would propose it to be around like the complaint component somewhere, right before or right after or in it somewhere. Because it's specifically related to somebody either filing a complaint or participating in the hearings, in the procedures. Or hearing rather. Actually, that's okay. Perhaps after 201, we talk about public hearing and then say, hey, you can, we don't, what's 102? Okay, I kind of like, I would think if you put it right after the public hearing component, because it relates to filing complaint or participating in the hearing. So we've said, here's a complaint, here's the hearing. By the way, if you retaliate against somebody that's participating in either of those, it's prohibited.
Yeah, that's a good idea, yeah.
So instead of, so where section 2-102 starts, it's right before. And then it goes into sanctions of violation of this article. So then what are the outcomes if you violate any of this stuff?
Well, good.
A new section and you're gonna 10 comes to that one.
So I know we've lapsed time. I will ask preliminarily, did anyone have any concerns? Or did anyone have a chance to review the form?
I did. Okay. So my only concerns is, and I know I talked to Meredith about this last time, under that last section, select violation you're reporting, so. For disclosure of gifts, it now reads acceptance and disclosure of gifts, so.
Okay.
And then I didn't know, did we wanna add a new violation of ex parte communication? Would that be a violation
Retaliation.
and retaliation?
So what I hear Ann saying is we need to just make sure all of these headings are in alignment with the code language.
And we've separated representations and appearances. They're combined. I don't know if that makes a difference, but I'm just thinking if someone is reading the
A 1-to-1,
code, yeah,
that makes sense.
like if they're like, oh, okay, I'm filing on this, and then they try to find it, yeah, matches up, exactly.
Does anyone have any other preliminary?
I think if someone has a question, they could contact your office or.
And that's in there.
Right. They're not sure of what to check. You can get that, figuring it out.
There's an email address on here. I think we have our revisions. Proposals for next meeting, 3 weeks from today. Is that what we're looking at?
Yeah.
And it's not Thanksgiving week. Yes. Any other comments or changes or items with respect to the code? for possibly our last iteration of revisions.
What did we decide on retaliation? I mean, I know we decided to put something in there and where do we decide this is what we want in there?
Or which clause are we borrowing from? We said Annapolis?
I said Annapolis, but adding city official language. So like removing the like private sector's verbiage, adding our code of ethics, like titling,
Okay,
reading it as its own section number.
I think that works.
I like it because it says retaliate versus some of these go into trying to explain like threaten or take act, like
Short and sweet.
I. But I also did say if there's some sort of language they need to tweak on that. We'll get to
November 13th.
review it. We're really close.
November 13th, next one.
There are no other comments or questions. Can I get a motion to adjourn?
Second.
Second, all in favor,
See ya.
Aye.
meeting
Can I
adjourned.
do a public service announcement?
Sure.
That's how I wore my bid, right? My Exchange Club is on the Field of Honor. We're displaying 2,000 American flags next to on the field next to the U of H. And if you'd like to participate by sponsoring a flag, I've got a sheet here. No pressure, but if you'd like to be a part of that, it's Veterans Day weekend. It's a Saturday, Sunday, Monday. I have collateral material.
Maybe been a flag.
Love it. A leaf behind. This started so organized. Now it's just it exploded.
All right.
Thank you.
It's pretty cool.
Oh,
Yeah.
I love a QR code. I gotta tell you, like.
Thank you all.
Thank you.